Hi, everyone. Thank you for joining us at this press briefing on the new wave of digital censorship in India. Just a few notes before we start. This session will be recorded and we're going to put the link up on YouTube in a few hours. My name is Riya Singh Soni. I'm the Asia Pacific Policy Fellow at Access Now, and I'm joined here by several of my colleagues, Ramanjeet Singh Chima, the Senior International Counsel and Asia Pacific Policy Director, and Alexia Skok, the Media Manager at Access Now, who's been helping set this up. Before we kick off, I want to go over a few things. As I mentioned, this is recorded. We're going to run this as follows. We're going to start with comments from our expert speakers and then open it up to questions. We really encourage the audience to ask lots of questions. If you can let us know by raising your hand, you can put it in the chat and I'll call upon you. I also just want to flag in terms of how we're arranging things. David has a flight to catch in about half an hour. And so if there are any pressing questions that you want to ask, if you could indicate that early, that would be great. So yeah, I'm going to introduce a great set of speakers. We've got David Kaye, the independent chair of the GNI and the former UN Special Rapporteur for Freedom of Speech. We've got Gayatri Kandadai, or Gaia, the Asia Policy Regional Director at the Association for Progressive Communication. Sushant Sinha, founder of Indian Qanun, and Siddharth Badarajan, founder and editor at The Wire, and member of the Digital News Publishers Association. Before I hand over to our excellent set of speakers, I also want to mention that Access Now has released a joint statement today with 13 other international NGOs on the wave of digital censorship that we're seeing in India, and making specific recommendations to the government and to companies to do more to resist what demands are being made of them. I'm just going to hand over briefly to Raman to talk about this statement before I go on to the speakers. Thanks, Raman.
Thank you so much, Riya. And I've also provided a link to the joint statement in the chat here, and it's also available live online. I know many people have it. But just to reiterate, international actors tracking free expression, privacy, and other protected rights are very concerned at developments in India. So 14 organizations, Access Now and 13 others, joined together to issue a joint position indicating that we believe that the current developments in India, both the moves towards censoring content, putting pressure on platforms to take down content and to be able to process user requests, and more recently moves to create a significantly draconian regulatory framework for online speech under the IT rules issued under the Information Technology Act in February 2021, are likely to result in an increasingly hostile environment for free speech online, not just on tech platforms, including intermediaries, social media platforms, and messaging services, but also digital news services that are regulated by a completely unlawful mechanism under these rules, as well as new mandates towards streaming video services and others. We therefore have called upon the government to suspend the implementation of these rules and to in fact review them, undertaking sustained and meaningful public consultation with full participation. We believe all website blocking orders that the government of India is issuing must be made available in the public domain, which they are currently not, and that they should also commit to not curtailing free speech, expression, the right to association, and privacy online. We also believe there are important measures that technology companies and platforms operating in India must take, which is they must uphold human rights responsibilities and mitigate any human rights harming mandates from the government of India. They must prioritize user rights and challenge any unlawful or overbroad demands by authorities. They must implement effective measures to protect privacy, free expression, and security. And more importantly, they must ensure that they follow proper due procedure under law, including international human rights law standards, when it comes to assessing any request from government agencies. They must not be complicit in censorship, and they must step up. And we believe these are urgent actions that both the private and public sectors in India must take.
Thanks, Raman. David, I'm going to hand it over to you first.
Great. Thank you so much for having me this morning. I want to just, and I'm sorry that I can only stay for a few moments. I want to start by noting that it was just about 6 years ago in the Shreya Singhal case that the Supreme Court of India really came to a conclusion that was rooted in basic freedom of expression standards in evaluating Indian law and the possibility of censorship. And I want to start there because I think it's important to recognize that in both the Indian constitution and more broadly in Indian law, predating the Modi government, let's say, there were strong indications that India was on a path for creating a kind of framework for the evaluation of regulation in India that was rooted in basic rule of law standards. And I think it's useful to start there, in part because that was actually a case that was decided during a RightsCon in Manila, the Philippines, 6 years ago. I remember the kind of joy that people were experiencing at that RightsCon. But it's useful to start there, I think, because it highlights how far India has come in the last several years. And I think the statement that was released highlights just that distance that has been traveled by India and by this government. But it's also important to highlight a couple of those changes and at least the themes of those changes. So one, you can go back several years to, not several, just a couple of years, to the way in which India responded to advocacy, to protest, and to its own decision-making with respect to Kashmir, where the Indian government took not just a kind of modest regulatory step to deal with the internet, but actually shut down communications across the region a couple of years ago, and expanded its shutdown and slowdown eventually of the internet in Kashmir, really for purposes of limiting communication, limiting freedom of expression, limiting the ability of people to communicate both within and without Kashmir. The other kinds of issues that we've seen in the last couple of years are perfectly within that space of thinking of protest and expression as things that have to be censored rather than integrated into public policy debate. And so we see that not just in the response to Kashmir, but the response to the farmers' protests. We see that in the way in which the government has responded to criticism of its COVID-19 policies. We see that in the near total lack of transparency around government demands to platforms and to individuals to restrict content across the board over the last several months, leading to really absurd situations where specific posts that are merely critical of government have been taken down in really secretive kinds of orders issued by the government against Twitter, Facebook, other platforms. And also, of course, in the broader sense, to attacks on individuals, and that is legal attacks, often bringing cases against individuals for their expression in the country. So I think that as we think about what's happening in India, and I really defer to the expertise of others on the panel as to what is happening on the ground with respect to specific regulatory moves and with respect to the particular kinds of pressures that people are facing, I think it's useful to put the situation into this broader set of trends of recent years of really diminishing respect for freedom of expression after a very kind of model kind of baseline that the Indian Supreme Court had originally stated just 6 years ago. So I'll stop there and thank everyone for their patience with me, and my apologies for having to leave so quickly.
Thank you. Thanks, David. Gaia, would you like to talk a little bit more about the context?
Thank you, David. Thank you, Ria. I think the way we could possibly go about it is to first sort of figure out the context, because we are discussing about online censorship at a time when the second wave of the pandemic has affected the lives of millions across the length and breadth of my country, right? Broken hearts and families are still trying to piece their lives back together. The extent of reliance or over-reliance on digital technologies at this time has been apparent. India is one of the few, if not the only country, to have exclusively relied on digital technology for vaccine delivery, and to a great extent, even for information dissemination. The effects of that are open for us to understand and decipher what we will from. Social media and digital tools have thus become sort of unwillingly or willingly central to our lives at a moment when the digital divide is so vast. The pandemic has unfortunately also made way for a steep increase or normalization of violation of freedom of expression and opinion. There are two specific problems. One is the targeting of speech of users, and another is the targeting of platforms, including digital news platforms or portals. This has been made possible not only through existing legislation, both offline and online specific ones, but also through the enactment of new legislation or rules. But what I will do is I'll try and focus on the users, because the other speakers will be in a better position to talk about the private sector and the impact of this on the private sector. As noted in a report by Article 14, there has been sort of a significant rise in the number of sedition cases in the last decade, and more specifically since 2014. This relates not only to online content, but also offline content. This increase has been specifically noted around the historic anti-CAA, the Citizenship Amendment Act protests, as well as the farmers' protest, including other important moments. A lot of this has to do with content that is critical of the government, its policies, speech against political entities or personnel, and also speech that is oddly deemed as anti-national. The constitutional validity of this very provision that is used to charge individuals for sedition is currently being challenged, and we would have to wait to see the outcome of that. But moving to content that is specific to online spaces, the kinds of censorship we are witnessing includes charges for content or posts relating, or other posts that are either written or even artistic, that is critical of the government, and more recently critical of the government's management of the COVID crisis. In some cases, including the state of Uttar Pradesh, seizure of property is being propounded for engaging in such speech, so-called fake speech. As has been discussed in many panels, even during RightsCon, there is very little transparency around data to understand takedown requests or how these arrests are done. For instance, recently, Instagram took down several accounts and messages relating to relief work around COVID, which was later termed as issues with automation or a glitch. This only confirms our fears around over-reliance on automation. Now, Facebook had taken down several accounts and content, including that of a poet who was critical of the Prime Minister. Temporarily, hashtag Resign Modi was blocked, which too was termed as a mistake. Now, recent findings of the oversight board of Facebook relating to a content that claimed genocide of farmers, which was subsequently restored, was also claimed to be an error, right? All this points to over censorship coming from different quarters and not only the government. But before all this, a slew of accounts were ordered to be taken down by the government, including that of Caravan magazine. Twitter restored that account after like public outrage about it, but this led to a massive fallout between Twitter and the government. What we need to be doing at this moment is to look more specifically at the information technology intermediary guidelines and digital media ethics code rules. It's quite a lot, so let's just call it intermediary rules for the moment. This has already been challenged by many individuals, collectives, companies, and artists in different jurisdictions across the country. This enactment came about in February this year, but is really coming into force more recently. Among many other things, there are three key issues or concerns with these rules. First, it expands the meaning of intermediaries to include OTT platforms like Netflix or Hotstar. and also brings into the gambit digital media portals like Caravan Magazine, the News Minute. Now, these were not really included in the earlier version of the rules. Second, it makes it possible to trace the origin of a message, breaking encryption. And third, it mandates takedown of content, failing which unilateral blocking is made possible. Now, compliance is mandatory, failing which individuals or authorities of these different bodies, platforms, could face jail time accompanied by huge fines. A significant worry with this edition of the rules is also the lack of effective remedy or oversight to in any way challenge these orders, given the really short time frame available for compliance. I mean, the context I described earlier leaves us in a situation of severe anxiety about how these rules are going to be used, and more importantly, how it is going to be used to legalize illegitimate clampdown on freedoms, which only is going to result in further shrinking of civic space. Now, the problem with these rules is argued by many is not only that it violates constitutional, internationally guaranteed rights, but it also violates the very act under which it was created. These rules pose a long-term problem to Indians. It's not only an immediate problem because it is unclear as to how different governments, not only the union government, how different state governments are going to end up using it across the country. I mean, in my assessment, it may well come back to harm or bite the very makers of these rules in different forms, since, as David noted, this problem has been enabled by successive governments dating, before 2014 even. Besides this, the rules, for reasons I mentioned above, also defies the logic, letter, and legacy of precious jurisprudence relating to rule of law, fundamental freedoms that our judiciary has evolved over decades. It really does break down a lot of those guarantees that we have had. I mean, another sort of external worry I have is also that these rules may end up, or rather, there's this fear of exporting of such a model to other jurisdictions, no? Especially since we live in a neighborhood that often draws inspiration from each other, given our common social, political, legal histories. But I mean, just to wrap up, while all this is on one side, another worrying reality persists, which is that while legitimate yet inconvenient speech is being actioned, hate speech is allowed to progress in its full form. These rules do little to mitigate that, and the recent Washington Post revelations give us a window into the operation of giants like Facebook, who have not only failed to address hate speech, it could be argued that they may well have shielded hate speech. Therefore, the argument is not that the private sector should not be regulated, but that this regulation should be discussed in a way and developed in a way that is in confirmation with our jurisprudence and doesn't do harm rather than remedy the situation. I think ultimately the voices that are affected by the current regulatory framework are religious and caste-based minorities, human rights defenders, women and gender diverse individuals. Essentially, all voices of dissent will suffer.
Thanks, Kaya. I just want to pause at this point and ask if anybody had any questions for David. I have one, and I'll start with that. David, the Indian government's justifying the rules they've issued, saying, well, other democracies have done the same. I was just wondering what your thoughts are on that.
Yeah, I mean, I think that's a good point to raise, and it actually tracks with what Gaia was just saying, in a way that, that others in the region might look to India as a model as well. I mean, clearly, there's a lot of problematic regulation around the world. There's a kind of rhetoric in democratic societies right now and in democratic governments that is inconsistent with the idea of protecting freedom of expression and other human rights online, and the Indian government is benefiting from that global debate. There's no question about it. But it's also deeply disingenuous. Most governments, particularly if we look to Europe right now and the kind of debate that's taking place in Brussels at the European Commission around new internet regulations, is relatively thoughtful. Even if we don't agree with all the particulars, it is open to civil society participation. It is transparent to a large degree. And so even if the outcomes sometimes aren't exactly what we think are consistent fully with human rights protections, they're proceeding in a rule of law oriented framework. And for India to complain or to explain its rules as similar to what's already been adopted in other democratic countries, I think is really, well, it's simply not true. And it's a reflection, I think, in some ways, of the reality that the government actually understands that its decision-making here is out of step with fundamental principles of human rights and rule of law. If anything, it's a self-indictment more than anything else.
Yeah, thank you for that. I see Devi has a question. Devi, would you like to ask that?
Yeah, hello. Hi, I just wanted to ask, because both Guy and David were speaking to tech companies and how they have been operating in this situation. And we've seen many times that they've said, it's glitches or they're mistakes, that technical errors. And to what extent, I'm thinking, should we be pushing on remedial actions where these result in rights violations? So I work on Southeast Asia. And for example, in Vietnam, there was this instance where they took down live streaming as the police were coming into a village and attacking villagers. And that was a direct influence on, what was happening in the village. And yeah, I just wanted to pose that question as a thought question out there.
Well, I mean, I'll just say a word and then unfortunately I have to leave. And I'd be very interested to hear what others think about this question. But David, it's a really good question, in part because so much of our discussion around government pressure and company compliance with government demands is at a level of just thinking about sort of the demand and the response. And we don't have a very mature conversation about the remedies that should be available to individuals in the situations where their content is taken down or where they're subject to attack online or other kinds of harms that might take place online that are cognizable as a matter of law. I think you're really just highlighting a deficiency in the framework around dealing with these issues, because we just so rarely talk about remedy. So I'm just glad you raised the question. I defer to others as to how they think both the platforms and governments and also the international community should be responding in a remedial sense.
Thank you, David. I'm going to, I'm just going to go to Siddharth now, if there aren't any more questions for David. Maybe you could build on what David pointed out about, a little bit of your experience of what these takedown orders have been like and how you expect digital news to be affected by these new rules. Thanks.
Okay, so we have at the Wire no direct experience of takedown orders ourselves, either from any social media company or any other kind of government directive. We have had run-ins with a couple of companies and politicians who filed defamation cases. So traditionally, the major form of, just for participants at RightsCon to understand, the traditional form of harassment of journalism in India, because we have, as people know, 6-7 decades of fairly robust jurisprudence defending freedom of the press. But the one loophole is defamation. And defamation is what was the preferred route for politicians, for governments, and for the corporate sector to harass and intimidate, preempt, and punish media platforms for publishing stories that they didn't like. So at The Wire, we've had our fair share of defamation cases, and we have developed a mechanism to deal with these. All of these cases are frivolous and time-consuming and wasteful on resources, money and time. But it's a known devil which one is able to deal with, both civil defamation as well as the more dangerous criminal defamation. But what's happened over the last few years is clearly the government looking for methods of harassment and methods of pressure and intimidation that produce a more direct and unmediated effect. So the problem with the establishment when it comes to defamation is that the matter goes to the court, and it's the court's call whether they grant an injunction or they don't, whether they find you guilty or they don't, whether they fine you or they don't. And because the Indian judiciary prides itself on its independence, so this is not something the executive can take for granted. So they have moved now, citing the allegedly unregulated nature of digital media, into a scenario where they say we need to have new rules and regulations to protect readers, protect the public at large, and to protect the country from the excesses of this unregulated Wild West that is digital news. And I said this is a myth because the fact that The Wire has been dragged to court, the fact that other digital platforms have been taken to court, incidentally, not just for defamation, because we've seen since the onset of the pandemic, the state getting the police to file direct criminal charges in relation to tweets, in relation to stories that they find unpalatable. And the fact that we are digital provides us no protection. We are as exposed and vulnerable to cases of this kind, which are full-fledged criminal cases, as any other kind of media platform. So the fact is that the experience of the last 2 or 3 years itself makes it very clear that digital media is not unregulated. It is not as if somebody who is aggrieved by content on a digital news platform does not know where to turn, does not know which door to knock on. Because there are many examples of platforms like mine, which have been subjected to pressure of one kind or the other, initiated on the basis of complaints. And so this idea that digital media needs to be regulated in some way because otherwise there's not a level playing field is utter rubbish. But this is the logic on which the government has proceeded in order to frame these IT rules, which are, to my mind, not just offensive and they're offensive to the concept of press freedom, but they would, if they are allowed to stand, very shortly sound the death knell for media freedom in this country, because the idea is to weaponize a system of complaints from so-called readers. And we know how politically motivated groups of individuals, often hand in glove or set in motion by the establishment or by the ruling party, know how to play this game very well. They know how to wield this weapon very well. So you create a situation where digital platforms have to comply with an illegal, in my mind, and unconstitutional, but ridiculously cumbersome grievance addressal mechanism, and then essentially hold a gun to our head for falling foul of that mechanism. If at the end of the day, a government committee decides that steps we have taken to address reader complaints are not adequate. So this represents a qualitatively new attack on digital media. It, of course, builds on a decade-long establishment practice, with the IT Act. I mean, the IT Act itself has lots of provisions which are misused. Section 66 may have been read down, but Section 67, which prohibits the electronic transmission of obscene or lascivious material, has been used against all kinds of legitimate media expression, against people on social media. So you can draw a cartoon that severely lampoons a chief minister or the prime minister, but would not be considered obscene if it were printed in a book or in a newspaper, because you have 7 decades of jurisprudence on what constitutes obscenity. Yet the police will say, because this cartoon has been disseminated electronically, it falls foul of the crime of the electronic dissemination of obscene material, and you get embroiled in a case. So there were lots of landmines in the IT Act and other laws that could have been invoked and were invoked. But what we are seeing with the new IT rules is a qualitative escalation of this offensive. We have gone to court, other digital media platforms have gone to court, and we are confident that when we have our day and we are able to put our arguments before the judge, the judiciary in India will see that these rules represent an illegal and unconstitutional attempt to stifle freedom of press. And that's what we are, where we are at right now.
Yeah, thank you for that. I just want to take a brief pause and see if there are any questions. Aditi, I saw that you had a question. Maybe you want to ask that?
Yes. Thank you, Ria. Thank you, Access Now, for organizing this panel discussion. So this is following up on what Devi had asked. Is it possible to quantify the harms of clamping down on freedom of expression online as it is done with right to privacy? For instance, if there's a data breach, there is still a fine imposed on the company. Is a similar thing possible here? Is there any kind of quantification possible? And the second question is to Mr. Vadrajan about if the effect is only on solely digital media like the Wire, the Scroll, the News Minute, etc., or does it also take into its ambit things like the website of the Indian Express or the Hindu? Because the latest letter that was sent by the MIB on 26th May also has an appendix for legacy publishers to furnish their details. So if you can throw some light on that.
Thanks, Aditi. Who would like to speak to the first question? Gaia, do you have any thoughts?
Look, I mean, in most litigation, it's usually costs that's sort of calculated on different fronts, no? And it's done quite differently. It's almost like how defamation is dealt with, no? So it's not really possible to give one sort of yardstick or meter, because it also then depends on a particular individual's reach and how much that content may or may not have reached. But I think Raman might probably be in a better position to reflect on that particular question.
Thanks, Guy. I'm happy to try and answer it. And in fact, I think it might relate to Siddharth's experience as well. So it will be a good setup for him, maybe respond a bit to that, and also the other question posed specifically to him. But for example, I think we need to remember that there are wide types of intermediaries. So the best example is those reporters or others who say regularly use commercial blogging platforms or providers to post their work can literally be able to compute the harm that's caused to them by not regularly reporting. Of course, any good journalist would say there's very little money in reporting, but there are ways you can compute and assess the impact it has on somebody's professional career. For those who are larger services, and I know, for example, that's not happened very regularly in India, but say imagine, say the Wire or other news services who exist who may use third-party providers to serve their data. That means, to either say host it or to run a content distribution network. It is an interruption there. They can talk about it, the number of viewers who can't regularly access it, and do a sense of computation about the sort of damage that is caused there. Of course, the ultimate reality is, at least in the Indian context, and so that emphasizes, look at past jurisprudence, India doesn't really award damages at all. It's the unfortunate reality of how our civil courts work, but you can get a sense of that. And of course, in public law, that is constitutional impact, judges take note of that seriously. But that's an initial sense of it. But it's very important for us to remember, as I keep saying, the number of people who come to me with questions about the ITR tools over the last 3 to 4 weeks, it's not just even the news platforms and not even the big social media intermediaries. Every intermediary, every pipe in between, from telecom companies to content distribution network companies to cybersecurity companies to companies who service ads through ad networks, they're all impacted by it. They all don't know how it will be affecting them. And that entire internet economy is impacted. But of course, my larger concern is the human rights impact of that, which again, we can document and do. And perhaps India is interesting that way because there is some initial work on the social and economic cost of internet shutdowns. But again, I know Siddharth might be able to talk about this a bit more, along with the other specific question pointed to him.
Yeah. So, the question on quantifying damages and harms, in 2015, the Bombay High Court, in a case, the case is called NSC versus Money Life, awarded 50 lakh rupees worth of damages to Money Life for what was essentially a bogus defamation suit that they had brought against the publication. So there is a precedent of the courts awarding damages for, shall we say, frivolous or punitive, suits, malified prosecutions of one kind or the other, civil suits. And the Indian Criminal Code, the IPC, of course, also has provision for going after public servants who engage in malicious prosecutions and so on. But those are very, very rarely invoked. And I don't think, even though many of the cases against us or the cases against, for example, the sedition case against Rajdeep Sardesai and Mrinal Pandey and others, or the case against Dua, which the Supreme Court recently dismissed, to my mind, in any democracy with rule of law, would be considered textbook cases of malicious prosecution, where steep fines and even more punitive measures against the erring police officials ought to have been imposed. But we're pretty far from there right now. I would be happy at this stage if we are able to fight off some of the pressure and some of the damage that is done to us. Later on, I think we can look to try to quantify and make a demand for punitive damages. On the second question, you're right. The IT rules apply to everybody. They apply to all digital media publishing. So that includes standalone digital publications like The Wire or News Minute or Quint, Scroll, etc. It also applies to the websites of so-called legacy media, all TV stations, for example, and in fact, the biggest websites, the biggest digital news websites in terms of traffic in India are run by, NDTV, Times of India, Indian Express, and they all are required to comply with this, with the IT rules. Also included, I should add, are any website, because the rules are drafted with such vague language that it would apply to, I would say, if you write a blog, a regular blog on where you comment and analyze on current affairs, the INB ministry could say, well, why aren't you registered with us? Where is your grievance officer? Because there is no there's no limitation of scale. In other words, there is no floor for the minimum number of readers that you have to have in order to comply with these rules. And essentially, they seem to be framed in such a way that the government can cherry pick. So if you run a blog that has a huge amount of traffic and influence, but is pro-government, then chances are that your non-compliance with the IT rules will go well below the radar. But if you are somebody who writes a blog that is critical of the establishment, no matter how small you are, you could very well run the risk of punitive action by the government for this. And I should also say that foreign newspapers and websites are not excluded. So the rule says that if you are a foreign publication that is in the business of systematically providing your content to people in India, then you have to comply. So the New York Times website is available. The Guardian, At one time, they used to have standalone India portals like India Inc. and so on, but they don't do that now, but it doesn't matter. The fact is that they are very keen to expand their leadership in India. They cover India extensively. They have offices and bureaus over here. And there is a question mark as to whether they need to comply too. And so this is really a very, very sweeping rule that can bring literally tens of thousands of publishers under its ambit, maybe even more. Why, for example, should your uncle's Facebook page, where he regularly posts comments and analysis about elections and corruption and what's going on in the country, surely that is also news and current affairs publication. So why would he be excluded from the need to have a grievance officer, for example, right? So these are all ambiguities in the law, which I think have been left in there deliberately so that the government is armed with the ability to go after anybody that it wants. I should also add, if I may, that the publishers of, in other words, newspapers and TV channels are, they met the minister and said, look, these rules shouldn't apply to us because we already come under the ambit of the Press Council of India or the Broadcast Act. And, so there is some attempt by them to wriggle out. It's possible the government may let them go. I don't know. But our response to that would be to say, well, if Press Council of India is the regulatory body, then make it applicable to everybody. Why let their ambit cover newspapers as well as digital publishers, and make it the Media Council of India. There is such a proposal floating around. Why do you need these IT rules in order to so-called erect the scaffolding of a regulatory system? So there's plenty to argue about, and we hope to have all these issues get clarified in the course of our litigation and struck down as ultra virus.
Yeah, thank you for that. And just to talk about the really wide net that these rules are casting, and I think this is a good point to bring Sushant in. Maybe you could talk a little bit about Indian Qanun and the kinds of takedown orders that you've seen. Yeah.
Hello, Ria, and hello, everyone else. Thanks for having me here. So I started Indian Qanun around 13, 14 years back. And my goal was just to make the search over Indian law and court judgments easier. So I just crawled the Supreme Court website, got the laws and put them together. At that time, I did not know about all the problems that can come with it. So I thought it was just to make law finding easier. I was just doing PhD at that time and did not think about much of the ramifications. Later, even though the court cases are public documents, a lot of court cases came up regarding removal. But most of those court cases were removals were actually went to court. And initially, I did not have any representation in many of these cases. But only later on, I realized that things can go wrong. And I started having lawyers for those cases. But I think those are still the crux of that is the privacy versus people right to know. And that is something that is not that direct harassment, though people have visited my house for case removal. And I have been summoned in Kerala High Court for a contempt case for not following the order, and people have beaten me there also. So that can also happen when court cases come up. But apart from that, I think there is a couple more interesting things that happen while I run the website. Is Jio as an ISP has blocked Indian Qanun for around 2-3 days. Somewhere I think 2-3 years back, and most of the people asked why that was blocked. They put up a notice saying as per the instructions of MIT. And since these rules are actually are supposed to be hidden or so-called the blocking, as per the blocking rules, they are not supposed to be given out. No one knows why the website was blocked. And later, I think around after 3 days, Geo has lifted the ban on its own. I filed an RTI request. Mighty did not give me anything saying why was the website blocked. So, I mean, one of the big problems of the confidential nature of these blocking is that no one knows the reason, no one has anything to challenge. I mean, since you don't have an order in front, you cannot go to the court to say this order is illegal. I mean, what are you going to challenge in the court? I mean, I think similar problems people find in the UAPA laws and similar security regulations, where many of the things are in sealed envelopes and there is nothing to challenge. And the judge has to, you cannot really question, can't see the evidence that has been presented against you. So that is one big problem. And I think other than that, even the cybercrime police keep sending me messages for takedown of court orders. And I have got enough thick skin to just tell them, no, these are court orders and you need actually a court order to remove them. The intermediary liability rules were, I mean, are really weaponized now, as Siddharth said. I have claimed in all my previous cases to be an intermediary because I'm just an intermediary of court publishing their laws. So in that respect, if I qualify as an intermediary, but now the rules are such that the takedown notices by government are really weaponized, that you need to have a grievance redressal mechanism, and the definition is also so broad of what qualifies as a news media or not, that even some may say that Indian Qanun also qualifies because it uploads daily court judgments. So that is what I feel are the problems with this. And I being a single person running the website was also a lot of ramifications, because people coming down to the home is also not, it hasn't had any inadvertent experience yet, but it may have. And that is why I will always kept my address secret till now for that reason. Okay.
Yeah, thanks for that, Sushanta. That, against that context, it's also important to note that Live Law Challenged has filed a challenge and has got a temporary injunction against the rules being enforced against them. So that's a really important point. I mean, there's a question that I wanted to pose, actually building on something that you said, is that a lot of the coverage is framing this as a battle between, big tech and the government. And I think the government is also keen to kind of frame it as that. Who else is kind of caught up in this battle, and what are the kind of consequences of that?
Who is this question to?
Who'd like to take it? Gaia, would you like to take it?
Yeah. So actually, it's a really good question about this particular set of rules has, as I said, broadened the ambit of who is intermediary, right? Now OTTs, digital media portals have all come into this. Now, actually, the bigger question now becomes this big Facebook, Twitter size platforms versus emerging alternatives, right? Already we've recognized that, and this goes back to the question that Devi had actually initially asked about remedial measures. And I had messaged her saying that remedial measures has little to do with the law and more to do with how these companies operate and the monopoly that they enjoy. No, I mean, there is no alternative, effective alternative at the moment for some of them. So for alternatives to emerge, small and medium sort of enterprises need to be able to survive. Now, what these rules effectively do is that they make it near impossible. Like for an organization like India Qanun, which is very well reputed, as you heard from Sushant, it's already sort of daunting, to deal with all of these. Imagine a startup trying to engage in this content space, the kind of burden that's going to fall on them, the amount of compliance that they would have to go for. They are not going to ruffle the feathers of the government. No, what they would actually end up doing is over compliance. And what would happen is they will preempt a situation where they might have to face the government. So they'll proactively start taking down content that is even mildly problematic. So that is actually what will happen. And that is the environment that this current rules is going to foster. Raman, is there anything to add on that?
In fact, I was just curious for Sushant's view, because I know like he's often on this, seeing that directly and directly also often, his content's indexed by other big tech players. So he sees the sort of tension they face. So I actually want to ask Sushant what you thought about this.
Framing the debate as big tech versus government is not the right debate, right? You are including everyone in the intermediary section. This is doesn't. Of course, in the news section, you expand that ambit even more, and you go to the OTT, you expand that even more. And the rules, even in the other segment, that applies to all the intermediary, are not lightweight rules. The grievance redressal has to be immediate almost, and within 24 hours. I usually take 2-3 days to actually implement a court order, because I have work lined up and other things to deal with. So even court order for me takes 2-3 days at least to get done. If they are going to ask 24-hour removal and things like that, then I think it's a very difficult for anyone to operate in that way.
And maybe I would briefly add to Sushant it's very important to note the requirements for significant social media intermediaries that can also include not-for-profit entities who do this, including perhaps the communication channels on, say, Wikimedia or other platforms. There's a data retention requirement for over half a year. So in fact, there are, imagine the cost, but also imagine platforms who say, yeah, we don't want to enable that because that is incredible harm on privacy, on many other measures. Of example, like imagine people focused on supporting journalists or others who would never keep data for that long, except related to a particular story, and also in a secure manner. It's directly, in fact, meant to facilitate surveillance, but also incredibly intrusive and damaging on the right to privacy, not to mention digital security more generally.
Yeah, thanks for that. I think we haven't talked about a lot of the privacy harms that these rules can introduce. I see that I wanted to check if there's any more questions. I see Aditi has a question to Gaia. Aditi, would you like?
Thank you, Ria. So Gaia, the question is that the rules and the code don't really expand the definition of intermediaries, do they? Instead, they rather create a new category of publishers of online curated content or publishers of news and current affairs content. And while they may overlap in terms of function, for instance, if the wire has a comment section, for the comment section, it becomes an intermediary. And for the news article itself, it's a publisher of news and current affairs content. But there have been attempts to silo the two, and therefore also silo the obligations there. Or did I misread something?
I just want to flag that I think we lost Kaya in between, maybe an issue. But if she's rejoining, because she warned me, if there's anything that goes towards on legal stuff, I would be her backup if there are connection issues. I can try and answer. That would be okay. Aditi, I apologize. When Gaya's back, she can try and answer as well. But I can do my best. And I think your point is absolutely valid. The rules technically do something worse. They categorize. That's not what Parliament intended. Parliament was very clear. It said there is this one definition of intermediary, which is very broad. And just by way of brief history, that's because everyone asked to be an intermediary back in 2005, when the process to amend the act happened after the famous Bazi case, where Anish Bajaj was arrested, because people said the purpose of this parent section 79, is to give legal protection, is to give a qualified legal immunity if you're an intermediary involved in handling other people's data, communication, messages, and you don't have full control. And therefore, because that was a protective section, everyone rushed in to be included in that definition. And ultimately, that's what Parliament signed off on. MPs, in their wisdom, in those 3 minutes that were there to clear the IT Act amendments, put that in. Now, what they've done is create a subcategorization. So the executive branch has gone ahead and basically perverted what Parliament did, to create a broad definition, subcategorize it, and put so many burdens there, which I think was what Sushant was saying, right? You now hesitate to say you're an intermediary because it actually makes your life much worse. And people who a couple of years ago in the tech sector who would have said, yeah, obviously we're intermediary, they're careful. Because, for example, are significant social media intermediaries telecom players as well, who may have social media functions now embedded? Like every telco has a sort of social network sort of embedded in their payments platform or whatever, right? Like Bharti Airtel reminds me of my family who are there, how to communicate. Are the full mandates on them as well? And I think that's what's happened there. But he's absolutely right. the rules didn't expand the definition of intermediary, but they perverted the purpose of it. And by subclassifying it, they created it and expanded its scope in a massive way. And one thing they did do is the rules try to cast within their ambit digital news publishers and others somehow within the if not the definition of intermediaries, within the government's rule-making powers for intermediaries, which is completely improper. And just to leave one last point, I think it's a struggle with the Ministry of Electronics and IT during previous administrations, but it's gotten worse with this administration, is that the IT Act is not their constituent assembly. They can't do anything they want there. It's a limited law passed by Parliament, as Siddharth mentioned, which already has problems in it, but it's a law where you have limited rule-making power. For example, under the IT Act, I can't say that, Riya Singh Sahni cannot appear on the internet at all for any reason because her name is that. You have to go with clear intent or limitation. And that doesn't seem to be the purpose. The idea is let's put in as much as we can, because otherwise we'll have to go to Parliament, and they probably will get that law anyway in Parliament if they did do that. But they're saying we don't even have to go through the pretense of that process.
Yeah, thanks for that, Raman. We're almost at the mark. We have a little bit of leeway to extend if there are any more questions. So I just wanted to check. Beatrice, please.
You're on mute.
Sorry, you're on mute. Yeah.
Apologies. My name is Beatrice. I work for the BBC in the United Kingdom. It's perhaps a question for Raman. We've talked a lot about the role of digital content platforms, but taking a step further in terms of the role of ISPs and mobile phone companies, what evidence is there to date that they have pushed back on any unlawful requests or overly broad requests?
So I can share based on my experience talking to different ISPs and working in industry and currently is that they do try and push back on requests. Some of them are publicly on record when website censorship orders were issued in India, even during the 2005 to 2009 period, particularly when at one point in time Blogspot was blocked. And in fact, that is probably a defining moment where, because that is so public and the pushback was so strong, the government felt stung by it. And I think the telecom industry told them that, look, don't do this again because this is what you're going to get. They, I think, have tried to tell them that in the context of internet shutdowns as well, but that's a separate topic. But what I can share is, for example, conversations where people in the telecom industry have said, well, actually, we've prevented them from doing horrible things sometimes, but they don't really review what they send us. We have tens of thousands of website blocking of websites that we have blocked over the years, and we are not even directed to clean them up. And it's a struggle. And for example, one, I unfortunately can't name the company, said that it actually impacts network performance. It impacts our filters and what we deploy there. And our users suffer because we are still implementing block lists that are out of date. What I think you'll notice is that when it comes to elements about the blocking rules, etc., the sector overall has tried to put some pressure back on the government. They said we prefer court orders coming to us, but they had this general position, which is that we are licensed by the government of India. Beyond a point, we cannot push back on them tremendously because they can just say, you're not following an order sent by the government. That itself is a violation of the license condition, even if the order is not lawful. And their risk appetite on that is low. And part of this, I think, also has been that sometimes they put the issue onto online platforms and they say, look, don't send the blocking orders to us, send it to them and get more regulatory power. Ironically, by passing these rules, the situation everybody's gotten worse. But these rules also apply to telcos, ISPs, edge providers, content distribution networks, all those sorts of actors as well. And they're wondering, oh, how do we actually now implement this? Do we retain data for up to 6 months if we have large amounts of data we keep? Do we have to appoint a compliance officer in India if we're a CDN or other things like that? And I think that's quite striking.
Thank you.
I'll just like to add one thing here. So in some time back, I think Mitsu actually was contacted by some influential people to bring down Indian Qanun. And then the Mitsu actually called me that time to check what is happening. And they actually cross-verified with me that nothing is illegal here. And in the way the other side has presented was that as if Indian Qanun was doing something illegal and the domain registrar needs to bring it down. So that happens again.
Yeah, thanks for that. I was just wondering if there's any more questions. Does anybody want to give any sort of final words as we wrap up? Maybe I can go to Siddharth first.
Yeah, no, I think it's great that RightsCon has flagged this because I think worldwide there needs to be greater awareness and discussion of the very precarious position that media freedom in general and digital media freedoms in particular are in. And if this is happening in a democracy with rule of law, then clearly the writing on the wall for the rest of the world is not very good. And we at The Wire, like many other digital platforms and other journalists and editors and publishers who are committed to media freedom, intend to fight this. And we are very confident that that we will get our day in court and prevail, because at the end of the day, there is such an intimate link between media freedom and digital freedoms on the one hand and democracy on the other, that the courts are going to recognize this and are going to say that in order to defend democracy in India, it's essential that there be no compromise with media freedom.
Yeah, thank you for that. Gaia, I think you're back. But your camera.
Yeah, I'm on my phone, so I don't have my camera on. I would actually make 2 points. Is that I think there needs to be more engagement. Actually, India is quite lucky because we have like a lot of really advanced digital rights groups, like SFLC, Internet Freedom Foundation, several. I can go naming now. So we're actually lucky. In comparison to other jurisdictions, we have quite a lot of experts. We also have digital rights experts beyond organizations, lawyers that understand the digital realm. But what is actually needed is a lot more engagement with the legal development in the regulatory framework beyond a legal perspective. There needs to be a sociological perspective, and therefore I hope that the media, that civil society engages more with digital regulatory developments. That's on the one hand. But as far as the political scenario goes, I feel that state governments, provincial governments need to start engaging the union government more and not play such a passive role in how the internet is regulated, because it has an impact on the lives of people, and state governments have a responsibility to safeguard that and not leave all of this just in the hands of sort of the union government, I would say.
Yeah, thank you. Finally, Sushant, if you had any final comments.
I mean, so the problem of the new rules aren't addressing the big tech problems or the hate related issues that are really there. When the new rules are just weaponizing government control over what can be given out or what can be available online. So in that respect, the rules are nothing to do with actually controlling the big tech. I mean, it is just to make sure all platforms actually obey what government does, and which is very different perspective on what free speech should be on. So I think the new rule should be just completely taken down, and new approach should be taken on what to do with hate speech and other problems that happen, and the law and order problems that happen. This is not needful at all.
Yeah, absolutely. Thank you for that. And it goes to something Gaia mentioned at the beginning also, that this is really not really help. It's not going to help. It's probably going to disproportionately affect communities that are already at risk and already face a lot of hate speech online. Raman, I was wondering if you had any final comments or additional questions.
I'm just very glad of a fantastic panel and people who've been here. And I think what people should also note and take away is the fact that this is so important. And I was just struck by the fact that India has come up in the comments of 2 significant tech company executives who have spoken at RightsCon, in the comments of Matthew Prince, who noted that, in fact, between the sometimes polarized positions of China and the United States, he's been looking at 2 other nodes for like influence and regulation, which is the European Union, doing things in a careful, considered way, not always right, but like doing it in a careful manner. And he in fact said, India was perhaps the most important one he was looking at, very, very important, but one which he was very concerned was taking a position actually much more closer to the sort of authoritarian position that some people in China take, which was troubling him. And that troubled me as an Indian who tracks and knows the impact India can have on democracies globally, which David Kay talked about, Siddharth has also talked about, others have talked about the impact we have in the region. And I think, therefore, there's a burden on all Indian policymakers, whether those who serve in the elected central government, Prime Minister Modi, his ministers, and the civil servants who aid him and who are appointed to public office, judges, regulators, whoever might be there to fix this, and particularly immediately put pause and perhaps rewind on these IT Act rules to fix other measures in terms of the broken system we have for web censorship in India. The first step of addressing a problem is acknowledging we have a problem and then going towards talking about it and fixing it. And then taking a sort of position where India truly, I think, can shine globally as the sort of champion for free expression, democracy that we wish to be, and also an effective rights-respecting approach to regulating big tech. I would have preferred a 2021 where we had a strong data protection and privacy law, an independent privacy commission, strong protections of government, surveillance and national security measures, and an approach to regulating big tech that other democracies would be tempted to follow. And instead, we are following a situation where other democracies at the very least should avoid or learn the mistakes of what India has been doing the last few months. But again, there's space to change this, and I hope that can be done. And I think it takes all of us to engage more. And I just wanted to thank people for taking time out to talk about this, because I think we all care very deeply on this topic, whether we're in the press, activism, tech, or wider communities tracking not just the future of the internet, but the present of the internet. India is the second largest internet user base in the world.
Yeah, thank you for that. And thanks everybody for joining us today and giving us time. I'm just going to put the email in case anybody has any more questions that they didn't manage to ask. Otherwise, that's it. And thank you.
Thank you. Thank you so much.
Thank you, everyone.
Thank you.
Thank you for doing this. See you.